So people know more and more these days about estate planning, but there's still a lot of questions that still need to be answered. One of the most common questions in Florida is, what documents are essential to my estate plan? And today we're going to be talking about exactly that. I will tell you the most important documents you need for your estate plan and why. My name is Jim Purdy and I'm the founder of the Purdy Firm, where we help Florida residents set up all the documents they need for their estate plan. So the first document is the last will and testament. Now, last will and testament is something that a lot of people are familiar with, but when we do it as part of an estate plan based on a living trust, which I'm going to talk about here in a minute. And so the last will and testament that you do as part of a trust-based estate plan is called a pour-over will. And the purpose of the pour-over will, we hope we never have to use it, to be frank, but we have it there as a safety net in case there's any property that you own when you pass that hasn't already been put into the trust for the trust to control. And all the pour-over will does is says simply any property of that nature that isn't already in the trust, I want to pour over into the trust. So it's all now being handled by the trust. If you set up your trust properly and you fund it properly, you won't ever have to use that. But again, it's there as a safety net. If you don't have a living trust and all you have is a will, then you're going to be in probate for sure, because a will is a creature of probate and the probate courts. And so the will has to be filed with the court, and the judge gets involved, and they'll issue orders, and there will be an accounting, and there's red tape and time. There are public records. It's not a private proceeding at all. And then you have to pay attorneys and appraisers and other professionals. So it costs a lot of time, it's a lot of money, and it's not a private transaction. So those are the main reasons why you want to avoid probate. And so having just a will is not a good idea for most people. So the second document that's important for you to know and understand, and what serves as the real basis for an effective estate plan in Florida, is the revocable living trust. So a revocable living trust is a document that you put together in your lifetime, and then you put your property into the trust. And so legally what happens is the trust owns your property. You don't own it as an individual. But don't worry, because you still control the property just as though you owned it personally, because you're going to name yourself as the trustee of the trust. And the trustee, of course, is the person who controls the trust and everything that's in it. So while you aren't controlling it individually as the individual owner, you're controlling it as the trustee of the trust that owns the property. So as a practical matter, nothing changes with regard to how you buy and sell and control your property, but legally that's a significant difference, that the trust owns it rather than you individually. That's what allows you to avoid probate. So the trust allows you to avoid probate, which saves you money and saves you time, and the trust is a private contractual arrangement, so it doesn't have court involvement in administering the trust. So you've got all those three really positive benefits, but there's more, because you can do more with the trust than you can do with the will. With the trust, you can pass on your inheritances in trust to your beneficiaries. With the will, it just goes directly to them, and you lose any kind of control over it or any kind of protections over your estate. But with a trust, you can set up what I call subtrusts. So when your beneficiaries inherit, they can inherit in a trust, and that trust can be established and set up in different kinds of ways to afford protections for your beneficiaries. So for example, if you have a child who has a drug problem and you don't want them to get their hands on a whole lot of money all at once and not have any control over it for them, you put it into a trust, and you can set it up with protections that they can only get that money for things like their own health, education, maintenance, and support. And so they would have to then be accountable to whoever you designate as the trustee to get funds, and the trustee would then have the ability to protect them from themselves in that scenario. You can also set up protections against other people, creditors or predators we call them, where with those proper protections in place, that if your child or other beneficiary has a creditor or somebody who's trying to get them, maybe a spouse and going through a divorce, and is trying to get their property from them, you can set up a trust that would protect them and protect the trust from that scenario. So there's lots of good reasons why a trust is preferable for the vast majority of people over just a will-based estate plan. Now the third document is a durable power of attorney. Now power of attorney is a document that allows whoever you name That's called your attorney in fact. You can name whoever you want as your attorney in fact, and they are then allowed with that power of attorney to conduct business on your behalf. And powers of attorney can either be general, meaning they can do anything you can do, or they can be special, meaning they're limited to whatever you put into the power of attorney. And so we actually do two different types of powers of attorney as part of our estate planning. We do a general durable power of attorney for most of your business to make sure your bills get paid, or your taxes are taken care of, or things of that nature. But we also do a specialized power of attorney called a healthcare surrogate. You can appoint somebody who will make healthcare decisions if you become incapacitated. So if you're in an accident and you're in a coma and the doctor needs permission to perform a procedure, well, they can't ask you because you're not available, but they can go to your healthcare surrogate because they've got that specialized power of attorney that allows them to make those types of decisions on your behalf. So those are the two types of powers of attorney that we do. The fourth document that is part of most estate plans is a living will. Now, a living will is kind of a misnomer because it's not a will at all. It's nothing like a last will and testament. A living will is an advanced directive where you tell your healthcare providers in advance what type of care that you want to receive in the event that you are incapacitated and you're in an irreversible condition, a coma, something like that, with no possibility of coming back to the semblance of a regular life. Those of you who've been around a while, you might remember the Terry Schiavo case from about 25 years ago now, where that was big in the news. There was a fight between her husband and her parents over whether they should pull the plug on her life support or not. She was in a coma. She'd been there for years. She wasn't coming out of it by all medical opinions, but there was a dispute among the family members. Well, a living will is a way for you to say in advance what you want to have happen in a situation like that. You can say, I don't want heroic measures. I don't want to be kept alive artificially. Essentially, go ahead and pull the plug if I'm in that kind of condition. Now, that's something that's entirely up to you. If you don't want that, you simply don't include it in your estate plan. But if you do, that's a good document to have as an advance directive. Now, the fifth document that you should consider as part of an estate plan is beneficiary designations. And this is going to vary depending upon your estate and what your desires are as far as putting the plan together. But you have a couple of options. You can designate for things like bank accounts. Well, life insurance is a good one. Everybody's familiar with life insurance, where you designate who the beneficiaries are that are going to receive the funds when you pass. But you can do the same thing for things like bank accounts or investment accounts and IRAs and 401ks and things of that nature. And you have a couple of options. You can choose to either designate individuals where they will receive directly whatever funds are available in those types of accounts, or you can choose to name your trust as the beneficiary. And that's what we typically will advise, but again, it will depend upon the circumstances. But the benefit of naming your trust as a beneficiary is the trust has the protections that we talked about earlier. And so the money isn't just going out without protection to the individuals named. It's going through the trust with whatever protections that you build into it. So that's the benefit of that. But again, as with all of these things, the exact composition of your estate plan is going to depend on you and your circumstances and your estate. So now that you know the documents that are essential for estate planning in Florida, but you don't know how to get started, so if you want to make sure that all these documents are legally sound and that your wishes will be followed accordingly, then click the link below and visit our website where you can book a virtual consultation with us. We'd be happy to talk to you and walk you through these options. Thank you for watching, and we'll see you next time.